It's no secret that Ripple and the SEC are attempting to settle their pending case in a way that would take it out of the public eye. In fact, many publications have recently cited sources saying that on Monday, July 10, 2023, Ripple and the United States Securities and Exchange Commission held a secret meeting and an open meeting to discuss the matter. The official page for this confidential meeting tells us that it will take place at 2 p.m. on Thursday, July 13th, and that it will be held indefinitely or at the Commission's headquarters. It also specifies that the meeting will be private and invitation only, and that neither attendees nor those who are not invited will be allowed into the building. Examples of such issues as interest-junctive actions, administrative proceedings, claim resolution in litigation and enforcement proceedings. Judge Torres, who will rule for or against the SEC, has put a lot of pressure on them to settle together, or at least meet and confer so that they can bring the lawsuit to a conclusion through a settlement rather than her having to make her own decision, which is what I think is happening here based on what I've seen in the public reports of their private behind closed. It's reasonable to assume that talks are taking place between Ripple and the SEC. Moreover, a meeting between Ripple and the SEC, the details of which have not been made public, is said to have been scheduled for July 10 of 2023. When you put the two dates together, it's clear that on July 10, 2023, Ripple and the SEC will likely meet to discuss a settlement. The rest of the settlement will gather together a few days after the Ripple SEC meeting on July 13 of 2023 to talk about what they think the Commission should do next, since this meeting fits in so well with everything else that's happening. I'm starting to think it's more likely than ever that it will actually take place, which is especially noteworthy given the lack of confirmation from official sources. However, the settlement discussion closed meeting scheduled for July 13, 2023 is listed on the CC website. If you haven't already, please click the like button and subscribe to the channel. It has been made quite clear by both Judge Torres and the former Judge Sarah Netburn that Ripple and the SEC must negotiate a resolution. In this case, on February 22, 2020, one Judge Sarah Netburn held a virtual petrol conference with Ripple and NDSU to discuss their legal strategy. Both judges have made it clear that they would prefer to see this case settled out of court rather than litigated, and they have recommended that Ripple and the SEC settlement talks. Since Congress has already made it clear that the best course of action for the SEC is to settle all of these claims and not use enforcement or regulation by enforcement as a means of providing clarity, it stands to reason that Ripple and the SEC should follow the judge's recommendation that they meet and confer about the possibility of settling the case. Even 2024 presidential candidate Patrick L. Riley is optimistic that Ripple and the SEC will settle. He noted that Arlington has recently registered with the SEC for an XRP-based hedge fund, and that many people find it fascinating that the SEC case is finally going to resolve, Time has come. This is in line with what Ripple has said. To summarize our conversation thus far, let's just say that it's looking very likely that Ripple and the SEC will reach a resolution within the next few weeks, which is very optimistic for XRPA. An official agreement between Ripple and the SEC could be announced at any time. All that remains is for the SEC and Ripple. A video in which Ripple CEO Brad Garlinghouse confirms that other companies will still need to pursue clarification if Ripple had misled them further strengthens the case. Please give this a like if you agree that XRP ought to be treated as a decentralized cryptocurrency rather than a security. In advance of Ripple's anticipated trial for alleged securities violations, the U.S. Securities and Exchange Commission, SEC, and the blockchain payments company stated on Monday that there is minimal likelihood of a settlement. The parties stated in a letter of discovery sent to federal judge Annalisa Torres of the Southern District of New York, U.S. District Court, that despite having previously discussed the issue, they do not believe there is a prospect for settlement at this time. Additionally, they pointed out that earlier settlement talks were held during the Trump administration and were mostly held with division directors who have since left the SEC. More generally, the letter discusses the formal procedure of exchanging information on the witnesses and evidence the parties will be using in the upcoming trial, with two parties either agreeing or disagreeing to it. The SEC filed a lawsuit against Ripple in December over alleged violations of federal securities laws. It claimed that without registering XRP as a security or applying for an exemption, the business CEO and chairman Chris Larsen sold over $1 billion in XRP to retail investors. Notably, the SEC informed the judge in a letter on Monday that it wants to take 5 additional depositions in addition to the customary 10, due to claims. Ripple and Larsen received 2 legal letters alerting them to the possibility that XRP would be viewed as an investment contract and subsequently a security under the federal securities laws. View more. Response from Ripple to SEC lawsuit regarding XRP sales. The documents are protected by the attorney, client privilege, according to Ripple, and the SEC request is improper and lacking in legal foundation. According to the regulator's letter, the SEC may seek the court to order Ripple to turn over certain records and pertinent deposition testimony. Andrew Hikes, an attorney at Carlton Fields, an adjunct professor at NYU Stern School of Business and NYU School of Law, called Ripple's ability to gain discovery, which allowed the SEC to give the blockchain startup disputed documents on Bitcoin and Ether, significant. Ripple will obtain previously unreleased information revealing the SEC position on the cryptocurrencies Bitcoin and Ethereum, both of which have not yet been regarded as securities. In order to have violated the same laws, Ripple has contended that it is entitled to access those documents. When it comes to Ethereum, which, like Ripple, sold tokens to divide its assets at launch, the information should be instructive, according to Hikes. The legal nod appeared to give Ripple CEO Brad Garlinghouse more power, but he is still in trouble. He is one of the defendants in the lawsuit, along with executive chairman Chris Larsen and Ripple Labs. Ripple has enormous financial resources and has assembled a superb legal team, which includes a number of former senior SEC officials. They look to have the resources to pursue the matter to a verdict and appeal. Unlike many huge enterprises that the SEC has sued, Ripple brought in USD $200 million in venture financing, valued at USD $10 billion. Hikes contends that it is too early to undermine their case. To date, the SEC interpretation and application of the securities laws to offerings and sales of digital assets has been supported by courts in virtually every instance, he stated. The lawyer predicts that a negotiated settlement is the most likely result. In high-stakes litigation, it's the most typical result. We stop here for now. Please forward this video to your loved ones.